Joding Sangha,
Yes.
Which is not objected to by Mr. H. Joding Sangha, Legal Aid Counsel, for respondent number 2, as well as Linda Faubel, the advocate, the additional PP. Okay, yes?
My Lord, I seek your Lordship's indulgence in mentioning an unlisted item. It's a bail application. My Lord,
Unlisted item today. What is the urgency? No, why not tomorrow, day after?
my Lord, since you're not sitting on Friday.
Bail application, he's
Yes, my
inside.
Lord. Yes, my Lord.
He's inside the jail.
Yes, my Lord.
So you make it tomorrow?
Yes, my
Okay.
Lord. If it can be posted for tomorrow.
Yes, okay. Listed for tomorrow then.
Oblige.
Daily list for admission, item 1.
Lordship, this matter has been
Yes.
sought to be sent for conciliation, but
Mediation.
mediation and conciliation.
Hacha.
In view of the difficulties in respect of the petitioners coming over to Aizawl, it is unlikely that the process will be, done
you could
by
not
way
take.
of conciliation.
Acha, you could not take the instruction from your client.
We have not been able to.
Acha. They would take instruction from the last order was you were supposed to take instructions.
Yes.
So what you can take telephonic instructions. They don't have to come down to Aizawl.
That is true, but Your Lordship, since there are so many, many writ petitioners are there.
Okay, then you try to take the instruction by the next date. Right?
That may also be futile, Your Lordship,
Because why?
because
you
it's
think,
difficult to contact them at this stage.
but then the petition is there. You are there for them.
Yes.
So how many writ petitioners are there? Many?
408.
Huh?
408.
Oh, 408.
Yes.
And there can be representations from the people, from the petitioners. But since mediation has already been referred for, so try to take the instruction. If not 408, some of them can give you and they can represent the others.
We'll try it again.
Okay. And what about the respondents?
As far as the respondent number 5 is concerned, we have consented to go for mediation. We have no,
Respondent number
five.
5 is who?
the NPCC.
Huh?
NPCC,
Oh, okay. NPCC.
yes,
Okay, there are, okay, respondent number 5 is the National Project Corporation.
yes.
And what about 1 to 10? They are the government.
These are
Okay.
the government, state.
Mm.
And 4 is the Union of India.
For his Union of India, I'm awaiting the decision from the concerned authority, my lord.
For mediation. So, okay, take
We'll
some,
fix
try,
another date.
because there is already an order from the Supreme Court. So, let us try our best to get the matter settled. So, right, in item number 1. Heard Mr. Learned Senior Counsel for the petitioner, assisted by, take the name, assisted by so-and-so, Learned Counsel for the petitioners, and Zoram Sang Pui, Learned CGSC, and Mr. Roshan Subedi
Yes,
for respondent number 5.
5, correct.
Respondent number 5. By the last order dated 31/7/2025, the direction was made to the parties concerned to take instructions from their clients as to whether the matter can be settled through mediation. However, when the matter is taken up today, the Learned Senior Counsel submitted that he is not able to get the full instructions on the said subject since there are so many petitioners and he could not contact all of them, and that he prays that some more time may be granted to him to get the said instruction. Mr. Roshan Subedi, appearing for respondent number 5, submits that respondent number 5 is agreeable to refer the matter for mediation. And Ms. Jarang Sangpai Pui, the Learned CGSE, however, submits that she also needs some more time to get the proper instruction from the said respondents, that is respondent number 1 to 4.
No, my
Five.
lord,
Four
respondent
only.
number 4.
Four only.
Respondent number 4. You are there for 1 to 3. You?
One is.
Ms. Veneshami? That in Zarang Sangpui you write, huh? 4, only in respect of respondent number 3. 4. And Ms. Veneshami appearing for respondent number 1 to 3, however, submits that there is no objection from the said respondents to refer the matter for mediation. The prayer made by learned senior counsel as well as Zarang Sangpui is allowed. Some more time may be granted to them to get the proper instruction. List the matter after 2 weeks. By that time, it is expected that the parties may give their full instructions.
Obliged.
Item 2.
2 is those, Zakir Hussain. Yes. You are there? What about your senior? He is there online? No.
No, my lord, he is appearing.
I'm
He's the
my
counsel.
lord, the council, but my lord, we have filed, my lord, objection regarding this petition, my lord. But I'm informed, my lord, that it is not on record before your lordship now.
Oh, the
I
objection.
think it's with the registry, maybe, lordship.
Oh.
And number 2, my lord, now I'm being led by senior counsel from Delhi, my lord, in this matter. So if it may kindly be taken up on Friday, my lord, day after tomorrow, my lord.
Friday it will be a problem. Friday we all are going to Itanagar, so Friday it will be a problem. Our flight is there at 2 and we have to leave by 12. By that time, giving the order and signing will be difficult.
Then Monday, my lord,
So,
next Monday.
but then see, on the last occasion I said that it will be taken up today because there is a keep this in the RTFI. There is a violation of Article 21. Because see, he has been granted bail, but he is not able to go out. And this is totally against 21 as well as that Girish Gandhi's case.
No, my
Do
lord.
it today, you are senior
In
enough.
fact,
Now,
Mr. Zoram
if-
Sana's junior was taking dates on prior, saying that Mr. Zoram Sana would appear. Now, my lords,
Now here I come, there is no doubt, my lord. Here
No,
I
no,
come
you-
today. But the problem now is that if that objection which you have filed yesterday may kindly be put to your buffer lordship today. my lord.
Okay, it can be brought. In the meantime, I'll take up other 2 matters. Or
In
other
both,
2 matters also.
also
you have
my
filed?
lord, also. All 3 matters, my lord.
my lords, it can be called. I've been informed. My lords.
But then it will take time, no? 5 to 10 minutes. Okay, then, 5 to 10 minutes, we'll call the objection. In the meantime,
My
I'll
lords,
hear
I
him.
can begin.
My lord, if it may be taken up tomorrow, my lord, for senior to appear through VC at least, my lord.
Your lordships, this
He
has
had
to
already
be
taken
proposed.
time. Today was, I told him to appear virtually. And now again tomorrow. How long it will go on tomorrow?
No,
tomorrow?
my lord, only tomorrow.
No, you do it. It's okay. I'm taking it up.
Actually, yes. It's up to
This
you,
is
lordship.
not a big matter. This is only bail for
I
onerous
understand, my lord.
conditions.
I understand.
Right. And the other matters where quashing and all are prayed are there pending. In those matters, okay.
My lord.
This is, I will see whether it is onerous or not. In fact, in my opinion, first one may not be a case where the conditions are onerous. And the other 2, okay, 50 lakhs, okay. That can be an onerous. But then again, in Girish Gandhi it is said, so many affairs, there will be so many conditions in different states, and then that cannot be allowed. Right.
Now, yes, my lord, taking into the seriousness of the offense which he is alleged to commit, my lord.
It's okay, offense will go on, trial will go on. What is there? Oh, our main endeavor should be that he should not go out, he should
My
not
lord,
abscond.
my lord.
And
also,
absconding, there will be conditions.
my lord, my lord.
Right. Okay, Mr. And call for the.
Your lordships, in item 2, criminal petition number 20, your lordships had said that, my lords, here the conditions are not so onerous. My lords, in item 3 and 4 is the conditions of the excessive bail bond amount. Apart from that, my lords, we are challenging the, one is, my lords, the condition that the sureties have to be government servants and those additional sureties, because altogether it would amount to 6 sureties. My lords, we are saying that we will try and satisfy the bail bond amount in item 2. Apart from that, my lords, I had discussed the matter with Mrs. Siami, the learned additional PP, my lords, and I had fairly conceded that yes, he is the prime accused. I will not shy away from that. But my lords, the sureties, she is pressing on that. My lords, I am saying, okay, let there be a surety. We will try and comply. But my lords, let it not be a government servant. Let it be a local surety. We will try and find. It is true, my lords. It is a serious matter, no doubt. At the same time, my lords, even the accused is trying. There will be some difficulty. Let the surety, my lords, we are saying, if your lordships find it good, my lords, that one surety may be there, local surety, residing
now, here
in
it is provided what? 2 sureties who are regular government servants.
government servants, and in the other matters, the
1 second, posted in an area
Yes.
lying within Aizawl Judicial District.
yes,
Okay. This is one of the 2 reliable sureties who are
regular government servants.
One government servant will do.
Your lordships,
And the second one is that shall not leave the jurisdiction or relocate his address presently in the police
police
records
records.
without permission.
my lords, he'll have to find new accommodation because he's been evicted from his earlier thing.
Rented house.
Yes, my lords, rented house. So, my lords, if your lordships find that a government servant should be there as a surety, we will try and comply, my lords. We have no other choice. And appropriately, we may take action if it can't be satisfied. Because, your lordships, it is, as I said, my lords, we understand the gravity of this case, my lords. So, my lords, if that is the condition, we will try and satisfy, my lords.
With 2 or 1?
My lords, if your lordships find it one government servant, my lords, I say it is fair, my lords. It is fair.
Okay. That I'll hear what they say.
Yes, ma'am.
But prima facie, what I find, 1 or 2. And number 4, if the court is satisfied, has failed to observe any of okay, he is okay, that is okay.
Yes, ma'am.
So your grievance is only in respect of 1 now.
Yes, yes, ma'am.
And 2 lakhs is okay.
2 lakhs, my lords.
2 lakh is okay. And relocating his address?
My lords, we'll have to, if the condition can be such that I may be able to find a new accommodation within the jurisdiction of this, within the capital city of Aizawl, my lords.
That is not unfair. Within the Aizawl district,
Yes, ma'am.
but he'll have to move to another place.
Yes.
Regarding that, my lord, now they cannot now say before a lordship which is the place of residence that they are now relocating to.
No,
So
what
it's
he's
very
saying
vague
is-
now, my lord.
Huh.
Very
No.
vague now.
No, what he is saying is he is thrown out of the present place. So he has to take some
So
other.
let them locate first, my lord, and approach your lordship.
Yes, Your Lordship. My humble submission will be that let him furnish his address so that we can make out that in which location he will be staying. So without
One
that,
thing it can be done. He
without
cannot
that, at
come-
this time, if the location is changed, what address will he be given before the court? He will be given his permanent address, and
No, not before the High Court. He will
Before
have
the
a new location and will inform the police.
exactly,
Yes.
Your Lordship. So first, let him find his location where he will be residing. So he will be written that address so that he may be located in that address.
Okay, then
My
he
lords-
will find a new place.
Yes.
Then you inform to the police.
I will.
Yes.
They will insert it in their records.
Yes, yes, my lords, that is the process that has to be done. But my lords, until and unless that condition is modified, then my lords, how can I proceed? That is the only thing. I will do that. I have to do
No,
that.
my lord, how can they now we modify? Otherwise, they have no specific submission before lordship saying that we are now relocating to this specific area and location point
No,
of
the new
place. So
condition-
now there
new
is very
condition-
vague now, my lord. What kind of order are they now expecting without relocating first, my lord?
No, see the condition here. Shall not leave the jurisdiction or relocate from his address presently in the police record.
Exactly,
He
my-
was not allowed to relocate. But what I will say is he will first find out where he will go and then he will inform the police. And that will be
That
inserted
will
in the
be
records.
prior to his release.
But prior to that, he will not go from this place. He will be here, wherever
Yes.
he is. He will now find a
He
new address.
specifically, yes, my lord. He specifically submitted before lordship now that he is no longer there and evicted in his presence place
Now
of
where are
residence.
you?
And
Now where
now
are you?
He is
Where will
already-
he
It's
go
only
now?
judicial custody.
Once released from judicial custody,
you
my
are in judicial custody, yeah.
once released from judicial custody, my lord. Suppose he is released from judicial custody by order of the Honorable Court, my lord. Where will he go? Very vague, my lord. He cannot say now.
Your Lordship,
No,
in the
you-
last,
he-
in the
he
last
has
court
always-
date, he already submitted that he was
It's a
already
flight risk, my
evicted.
lord.
He is
Wait, one
already
by one.
evicted.
One
He's-
by one, okay,
Yes,
one by
he is
one.
already evicted. So that means now he didn't have any location where to be staying in Aizawl or in Mizoram. So first let him find his location, let him find his rented house, and giving that address to, before the
By way of
police.
affidavit, he will
And after
submit
that,
his
we
place
will
of
have this
residence.
hearing, so that we can make out that where he is staying and we
this
can
is
locate his actual address.
Quite absurd, I have to say, my lords. How can I find a location if I'm still in judicial custody?
No, my lord, he
How
is
can I-
having
I
his
don't even have-
family
Where
also.
is your family?
My
His
lords, my
family
family is
also,
in,
they can very well come up before hearing.
No, no, where is
my lords, my family is in Assam.
Assam.
Yes.
So
Tejpur.
now he is
Yes,
also
Pranab.
having someone to depose affidavit on his behalf also, my lord. So that one can also go and find it, my lord.
My lords, this court, your lordships, put it simply, this honorable court, your lordships had rightly said, I have to report to the trial court and the police, I have to do that. I don't understand, my lords, how the condition is totally perverse, the relief that I'm seeking. That is the ultimate normal course that I have to follow anyway, my lords. And until I come out, how can I, my lords, then say, because then I will be, then they will say, your family has rented it, you have not rented it. So how can I prove my residential?
There is no assurance, my lord, that he will be absconding.
My lords, see, they've
But
seized
then,
all from
how
me.
can he, then what is the purpose of giving him bail then?
My lord, exactly. Now, let his relative find a fixed relocated place, my lord. Then only then he will come before lordship with affidavit saying that this is my present relocated place of living, and then he will be assured that he is present,
Otherwise, as
permanently
you-
residing therein, and then he will not abscond the court, my lord.
Otherwise, this condition has no value. He has no place now, right? He has no place
Exactly,
now.
that is the reason why we are very much afraid that he will, the moment he is released from judicial custody, my lord, there is a flight risk.
He will not abscond. There are sureties. One will be a government servant. And then he has to, I'll make that condition. Otherwise, see.
And that also, my lord, that very same surety's condition he is now challenging, my lord. Actually, he is a prime accused in a case wherein the total amount of
Yes,
money
that I know.
involved is 150 crores, my lord.
That we know. But then the fact is, he is given bail.
He is a prime
Only
accused,
because of
Lord.
conditions he is not out. That's total a violation of 21. Acha, see Girish Gandhi's case. Okay, you don't give bail then. But then giving bail and giving conditions which cannot amount him to go out is totally a
No,
violation.
my lord, my
So what
my-
I am suggesting is,
what I'm suggesting, my lord, before Lordship, is that let him find a relocated place of living through
No,
his
how can
relative,
he?
through his relative, my lord,
No,
through his
he-
relative,
see.
through his, he is also having someone else now deposing this present petition before this honorable court, my lord, and that
Hey,
same
how can
person
you-
can also
see,
go
see.
there and find some place,
No, see,
or
you-
his
you-
wife can also come up, my lord.
Okay, you are saying that he is involved in such a big scam, right?
my lord.
And then you expect the family members to come and here find out a place. It cannot be, it's not possible. They
How,
will
my
not
lord?
come.
It is possible, my lord, very much possible,
They
my
will
lord.
not, they will not, they will be afraid in coming here
No,
and
no,
say,
no,
and
Lordship,
no
so
one will give them a place.
They are not afraid. They
My
keep
lords,
on
with
living
utmost
here
respect-
also, my lord.
Your lordships, with utmost respect, there are 22 accused. All of them have been out except for 2. The current petitioner and one Manoj Sunu.
Okay, that I will decide. And what about this is the only thing?
This is in item 2.
Huh.
Item 3 and 4 are the more
Item 2,
controversial.
only these two conditions, right?
Yes, my lords.
Okay, then item 3.
Item,
Acha, what is your objection here? It has come.
Zoram.
My lord,
The objection has come. What did you refer to that? What did you write here? Achha, first is on the allegations.
Briefly, my lords, as per what I've understood from the counter is that, my lords, they've gone again on merits. It cannot be a
the-
rehearing on the bail, my lords.
Okay, no, they have also mentioned about some bail conditions here in
Yes.
Roman 2. 2 lakhs to be deposited and furnished to government securities, prohibiting
That is very,
relocate,
very, very reasonable,
is
my lord.
suitable consideration. The
Yes.
deep involvement.
A
of
very
the
lenient view on the part of the
Acha,
learned
being
law
the
court, my
highest
lord.
functionary
Very
and-
lenient, actually, my lord.
Mhm.
2 lakhs compared to 150 crores of.
No, 2 lakhs is okay. That he is not objecting. He will give.
Right.
Played a pivotal role by providing assistance and activity. You have written here unjust to set aside. I am not setting aside the conditions. They are not praying for setting aside. They are just one modifications. Right. This in Roman 5, your statements are not according to the prayer. Okay. Then the next matter.
My lords, in item.
Okay, we will go to the next matter. I'll
Yes.
dictate this one first.
My lords.
Otherwise, it will get jumbled up.
Your lordships.
Okay. So right after I dictate this. Okay, Michael. After I dictate this. So right. Heard Mr. Jordan Ramingtonga, learned counsel appearing for the applicant, for the petitioner.
Petitioner, my lords.
For the petitioner. Also heard Mr. Joram Chana.
Joram Chana, my lord.
Joram Chana. Mr. C. Joram Chana, learned counsel appearing for respondent number 2, and Venishami, learned counsel APP appearing for respondent number 1. This application has been filed under section 528, read with section 438 and 442 of the BNSS for modification of the order dated 22/5/2025 passed by the Judicial Magistrate First Class 3, Aizawl Judicial District, Mizoram. Full stop. By the said order, the learned court had the learned court, while allowing the petitioner to go on bail, had made it subject to certain conditions. Number 1, the petitioner to furnish a bail bond of rupees 2 lakhs to be deposited in the account branch. 2, the petitioner shall furnish 2 reliable sureties who are regular government servants posted in the area lying within Aizawl Judicial District. Number 2, the petitioner shall not leave the jurisdiction of this court or relocate from his present address, which was given in the police record, without the permission of this court. In fact, this condition number 2 has no value now. Now the police address that he has given in police record is no longer the address, he is evicted.
Yes.
Right.
Yes.
Without the permission of the court. I've said that. Okay. Number 3, the petitioner shall not influence witnesses or cause directly or indirectly the destruction or disappearance of any material as may be felt by the police to have evidentiary value. And number 4, if the petitioner fails to comply with the conditions of the bail order, he may be arrested in similar or other offences punishable under the law, and that his bail shall also be liable to be cancelled. With these 4 conditions, the learned court had granted bail to the petitioner by order dated 22/5/2025. Mr. Jordan, in fact, Mr. Consul, what has been done in also Mr. Counsel Romang Changa, right? And,
Yes, Your Lordship.
in the Girish Gandhi's case, what they did is right. They had given conditions with respect to all the other cases.
Yes, yes. My lords, there were around 4 to 5 states, Kerala, UP and so forth. There, my lords, for each state, there was one condition. But it had referred to, my lords, I have given a compilation of judgments. They had referred to one case. This is, my lords, Hani Nishad versus State of UP in para 28, my lords.
Which one?
Para 28, I've made a compilation, my lords. This
Para
would be-
28.
Yes,
Hani Nishad.
Hani Nishad. Here, my lords, this was regarding, in this court in Hani Nishad versus State of UP, has made the following order in a situation where the petitioner was faced with 31 cases. Considering the submissions, the impugned order, Hani Nishad so-and-so, is modified to the extent that the petitioner shall execute a personal bond for rupees 30,000 and the same bond shall hold good for all 31 cases. There shall be 2 sureties who shall execute the bond for 30,000, which bond shall hold good for all 31 cases. It is
This is what I wanted to do, because again giving
No, my
3 types of conditions in 3 cases, modifying it, will serve no purpose. So it will be in respect of all the 3 cases. See how it is done in Hani Nishad's case, which bond shall hold good for all the 31 cases. It is clarified that the personal bonds were executed by the petitioner and the bonds were executed by the 2 sureties shall hold good for all the 31 cases. This is the right procedure. Then what does paragraph 29 says?
My lords, here it talks about that a policy decision taken by the Honorable Supreme Court, my lords. If I may just come to the quoted part, the 2 relevant directions are extracted here under. If the bail bonds are not furnished within 1 month from the date of grant of bail, the court concerned may so move to take up the case and consider whether the conditions of bail require modification, relaxation.
No, my lord.
One of the reasons which delays the release of the accused convict is the insistence upon local surety. It is suggested that in such cases the courts may not impose the condition of local surety. My lords. Para 31 to 37 are those, my lords, different states.
Para 31 to 37.
Yes, my lords. I have not extracted those.
So say here they have said if the bail bonds are not furnished within 1 month,
Yes.
then we'll take up suo moto
Yes.
for conditions to be relaxed.
Your lordships,
Yes.
may I take your lordships to the 7th judgment, last page of this compilation, Satender Kumar Antil. And your lordships may just see para 100.8. Your lordship, the books are here in case your lordships.
No, it's okay. The High Courts are directed to undertake the exercise.
Of finding out the under trial prisoners who are not able to comply with the bail conditions. After doing so, appropriate action will have to be taken in light of section 440 of the code, facilitating the release, my lords.
What is 440?
My lords, the surety.
Surety.
Yes, my lords.
So what I'll do is I'll give those conditions, modify in respect of all the 3.
All the
And
3,
it will be applicable for all the 3. I'll give conditions, don't worry, he will not run away.
My lord, now the present case is very distinct, my lord. It's one of a kind case, my lord. So it cannot now be equated or treated at par with all these earlier cases which my learned friend has now recited, my lord. For that, my lord, I let him finish first, my lord. So I'll take
No,
my
I was dictating, in fact I asked in
Oh.
between. So let me dictate the
Yes.
initial part. Okay,
My
what
lord.
did I say? Mr. Jordan Ramingtonga, appearing for the petitioner, by filing this petition, seeks modification, not in respect of all the 4 conditions, but in respect of 2 of the conditions given by the learned court, and they are the condition where the petitioner was directed to furnish 2 reliable sureties who are regular government servants posted in the area lying within Aizawl Judicial District, and the direction given to the petitioner not to relocate his address, which was given in the police records, without the permission of the court. Mr. Counsel appearing for the petitioner submits that although the bail order was given in the month of May 2025, the petitioner has not been able to comply with the conditions, and as such, he is not able to get any relief, even if the bail was granted, even though the bail was granted. He submits that the petitioner has not been able to get 2 reliable sureties who has to be regular government servants working in the area, in view of the fact that he has been made the prime accused in a scam involving how many? What is this
150
scam?
crores is the allegation, madam. 150 crores.
150 crores, involving 150 crores of public money. Mr. Counsel also submits that the place that where he was living before the instant occurrence was no longer, which was also recorded in the police records, is no longer his present address, since the owner of the said house had evicted him from there. He also states that the family of the petitioner, earlier also family was in Assam and
Oh,
he
my
was
lords,
alone here.
They were all here.
Oh,
In
they were
fact,
all here.
yes, my lords, the youngest child, I've affixed the birth certificate. She was born here, my lords.
The family who was also with him in the said rented place left the same and are presently staying in the state of Mizoram, state of Assam, more specifically in Tejpur,
Tezpur district.
in the district of Tejpur. Mr. C. Valnan Chama, Zoram Chama,
Joram Chana.
C. Joram Chana,
Si Joram Chana.
appearing for respondent number 2, however, vehemently objects to the modification of the said prayers
My lord.
on the ground that that the petitioner, being involved in such a big scam, is likely to abscond if those conditions are not fulfilled. He as such supports the conditions, saying that the 2 local sureties who has to be a regular government servant posted in Aizawl is required in the facts of the case. He also submits that allowing the petitioner to relocate his address would give him an opportunity to abscond from the state of Mizoram, more so from the city of Aizawl. Right?
And my lord, if I may submit, my lord, number one point which I'd like to raise before lordship today is number one, before the learned trial court, wherein they prayed for and were granted this bill order, my lord, they in their application submitted that they will abide by any condition imposed by the trial court, my lord.
And that will do, everyone
So,
says it's okay.
the present condition which they assailed before your lordship is the condition imposed, which they said earlier that they will abide by. So they cannot now, under 482 of CRPC, my lord,
No, after
challenge it, my lord.
After seeing so many decisions, how can you say that? You see, okay, when one applies for bail, he always says, yes, I will abide by whatever conditions are given.
My lord.
But then they did not say that these will be the conditions and I cannot. These
So, the
conditions were
only
given by
thing-
the court.
They actually, my lord, stopped from challenging the same order which they said they would accept it.
Whether they said that if we were
It is in
given-
their application before the learned trial court, my lord. Before the learned trial court, they made a submission saying that they will abide by the condition imposed by the court, learned trial
Okay,
court,
yes.
in bail order, my lord. Number one.
Yeah, that is there in respect of all cases, that is there. Then
Number two, my lord. Number two, the present case wherein my learned friend has relied on is a completely different case, my lord. In this case, particularly,
one second, I'll just
number
write
one,
down-
my lord.
I'll just write down your arguments. Wait. First one, you said that they have agreed to the conditions.
My lord, yes.
Then,
Then number two, your lordship, particularly in respect of this
judgments.
Sandeep Jain case, my lord, reported in 2000, volume 2, SCC 66, my lord. This is the case wherein the petitioner therein were directed to deposit the amount of bail bond, my lord.
2 lakhs.
2 lakhs, yes. But herein this petition item number 3 and 4, my lord, today before lordship, they are not required to deposit. It's only a bail bond, my lord.
No, no, 2
Bond to
lakhs, 2
sign.
lakhs he is not opposing. He will pay. He will
Yeah.
give. He will submit.
They have not assailed the amount in 2 lakhs, ma'am. But I think now we have taken up all the cases 2 and 3 also, 3 and 4 also.
No,
Since, your
perhaps this is for his 50 lakhs. Because
Yes.
2 lakhs is said to be excessive here in Sandeep. Can he be detained endlessly for his inability to pay the amount of 2 lakhs? But okay, here he is a big person, he has his money, he
My
is,
lord, my
is a moneyed person. So he can afford this 2 lakh, but 50 lakh is too much because of the freezing of his account.
that he need not deposit, my lord. If your lordship take a look at the order itself, which is impugned today, my lord, in item number 3 and 4, my lord.
3 and 4 I'll go, let us finish 2. 2 he will deposit 2 lakhs along with
Yes.
the other conditions when
Num-
he will
My lord,
will released.
that specific ground, my lord, I'll not take
As
up.
far as item number 2 is concerned, what are your grounds? You tell me.
Next, my lord, next.
Huh.
Without that, now, since this is economic offense, if I may take lordship to one citation, my lord. 2024, my lord, volume 10, SEC 753. From paragraph number 18 to 20 and also 24, my lord. With your lordship kind permission, if I may read the lordship.
This is understood that economic offences should not be leniently.
So
dealt
that is
with and
exactly
all.
why, my lord, the citations which my learned friend had relied on actually has no application in the present case. That is what I am now trying to project before your lordship today.
20. in Anjar.
Yes, in this case, my lord, paragraph
Ajwar.
number 18, right from paragraph 18, my lord, page 762, my lord. Courts, while granting bail, are required to consider relevant factors such as nature of the accusation, role ascribed to the accused, concern, possibilities, chances of tampering with the evidence and or witnesses, antecedents, flight risk, etc. Speaking through Himakuli, justice, the present quorum in so and so, I propose relevant parameters for granting bail. Observe, well, considering as to whether bail ought to be granted in a matter involving a serious criminal offense, the court must consider relevant factors like the nature of the accusations made against the accused.
This is okay, this is not relevant,
No,
this is
these
while
are
granting
for
bail.
while granting bail, my lord.
While granting bail.
My lord, please,
This is conditions.
kindly bear, my lord, kindly bear me, kindly
Cannot
bear
be
with me.
rehearing, my lord.
Don't, I mean, it's
Kindly
not
bear with
wasting
me.
the time.
I know very well that now the question of bail or not already settled, my
You
but
go for
now,
cancellation.
now the condition, it has prescribed certain condition which,
I think they have gone for cancellation also.
They have, my
You have filed cancellation, your argument, this
My lord,
argument
yes.
These will
denied
apply
it.
there, my lord.
exactly, I know, my lord. Please kindly bear with me, bear through what I am reading, my lord. And in that case, my lord, if I may skip to paragraph number 24, my lord. In cases where the allegations coupled with materials brought on record by investigating the nature of economic offense affecting large number of people reveal active role of the accused seeking unsecured bail or regular bail, it would be fit for the court granting bail to impose appropriate, strict and additional conditions, my lord.
Yes, yes.
So now they are assailing before Lordship the strict and additional conditions which the learned
But
trial
then
court has imposed,
why,
my lord.
but why are you not considering?
We have to-
Because of those conditions, he has been inside for so long. That is violation. Why don't you consider that?
No, my lord, it is a very
Okay,
rare case, my
granting
lord.
strict conditions, I
Strict
agree.
conditions.
He
Since
should-
it's a
he
high-
should- but he is not able to go out, even when the bail is
Definitely,
granted.
my lord, definitely.
So that is totally a different case.
No, my lord, he should have, he
Your
cannot
Lordship,
be
Sanjeev
treated
Chandra.
at par. He
Yeah.
cannot be treated at par with those common men, my lord.
My lord,
In-
that is
in
a
respect
separate
of which
issue.
case?
Now you are confusing with bail and the conditions. So don't worry. I will give. It's not that I will let him go without conditions. There will be conditions. But then otherwise, there is no purpose of giving bail. That is deprecated by the Supreme Court.
No, my lord,
Lordships,
those
in Sanjeev
ones
Chandra, I have to
say-
wherein,
This will
my
not-
lord,
this will
the,
not end. Let me
the
pass
apex
on.
court
Yes,
has
yes,
deprecated are the ones
let us not-
wherein the accused petitioners are common men, my lord, not those involved in high.
In fact, you should have. Done the matter about cancellation of bail.
That already
immediately
filed, my
after
lord.
this bail. You are taking
Already
time
filed,
there.
my lord,
And your
is now
lordship,
due
Sanjay
for.
Chandra, your lordship knows, was relating to the 2G scam, where my lords 1 lakh crore was there. The bail conditions were, my lords, also the Honorable Supreme Court looked into those.
You go for cancellation, even if
Already
he goes
done,
out,
my
you
lord.
go
My-
for
now
cancellation.
That condition has to be stricter than those common men's case, my lord.
That
So
is
it
okay.
were, my lords, they should have also
That
filed.
is fine.
Now,
That is why government servant. That is why the information.
actually, my lord, these government servant surety are actually those, here it's a very common practice to impose on those conditions, even in petty cases here
It's
in
okay,
Mysore.
it's okay. But what is your subsequent? This judgment will not do. Okay, stricter condition, fine. He has been given in stricter condition, but he's
So,
not
my
able
lord.
to go out.
So
Okay.
actually,
Okay,
yes,
then,
my lord.
Then right. And before I write, I dictated his submissions. You give Mr. Jordan Romingtonga, in order to substantiate his argument, has placed reliance on the following cases. One, sit, Mr. Jordan Chamba. I know your predicament, but then this is not done. There has to be. Something has to be. You go for cancellation, it will be cancelled. Fine, he will be inside again. If he violates the conditions of the bail.
Your lordships, I just want to point out that insofar as this FIR, he was arrested in April on paper, but he was actually kept in custody since 29th March 24 with regard to the
It's
other.
okay, he
Just-
being custody is fine, but from the bail order,
Yes.
this is wrong. He may be okay, but from the bail order, that he should not be.
Yes.
Then, okay, he placed reliance on Sandeep Jain versus National Capital Territory of Delhi, reported in 2000 volume 2 SCC 66, by which the Honorable Supreme Court had observed that keeping in prison the accused person for a long period where bail would normally be granted for the offences alleged is not only hard but improper. It was also observed that if there is any failure to raise funds with regard to the bail bonds, the court could have directed the appellant to substitute him funds, raise funds for honoring the checks issued by the surety, right?
Yes, ma'am.
For honoring the checks issued by the surety, the court should have directed the appellant to substitute him with another surety. But keeping him in jail would be unfair. And that the excessive bail conditions imposed upon the appellant was modified. On the ground that the same would result in refusal to the grant of bail. Second, Sanjay Chandra versus CBI, reported in 2012 1 SCC 40. By which the Honorable Supreme Court has observed that the refusal of bail to an unconvicted person is unfair. Number 3, Motiram versus State of MP, reported in 1978 4 SCC 47, by which the Apex Court had observed that asking the accused person, like such as a mason, to furnish sureties of 10,000 is shocking. And then Girish Gandhi versus State of UP, reported in 2410 SCC 674, by which the Apex Court had observed that the principal has been that excessive bail is no bail, and that to grant bail and thereafter to impose excessive and onerous condition is to take away, is like taking away, is like taking away with the left hand what is given with the right. Then Satyendra Kumar Until versus CBI reported in 2210 SCC 51, by which the apex court had observed that imposing a condition which is impossible of compliance would be defeating the very object of release. So many judgments, 1, 2 would have been enough.
My lords, all may not be quoted. It's
Nani
the same
Nishad, I'll quote.
Yes.
This Nani Nishad, Hani Nishad, H. Hani Nishad versus State of UP versus reported in, this is an online, 2018 SCC online, SC 3946, by which the Honorable Apex Court had modified the conditions of the bail by making it applicable to other cases which were 31 in numbers against the applicant. Even that policy, okay, another one, policy strategy for grant of bail in re, reported in 2024 10 SCC 685, by which the apex court had observed that if bail bonds are not furnished within 1 month from the grant of bail, the court may take up the case suo motu and modify the conditions. Then you go to see Zoram Chana, he objects, right? Then Zoram Chana's, no, see, last, Zoram Chana's submissions you give, that he also submits that the case is a very serious in nature and that stricter conditions were as such put while allowing the bail to the petitioner, and the same is permissible in the facts of the case. He also stated that the applicants, while praying for bail, had agreed to whatever conditions are put to them, and that now turning around and challenging the conditions cannot be allowed under the inherent power of this court. Right?
My lord.
I have heard the counsel.
And my citation, my lord, please.
Oh yes, yes. He has relied on the judgments passed by this 2024, passed in,
In the case of Manik Madhukar Survey, Nadas versus,
yes, Manik Madhukar Sarve, SARVE, and others versus Vitthal Dumuji Mehar,
reported in
2024 10 SCC 753, by which the apex court,
at para number 24.
yes, apex court had observed
This may be reproduced, ma'am. Reproduced till additional conditions.
okay, then you quote this, But first of all, okay, I had observed that that in cases of economic nature or offences where large number of people offences affecting a large number of people are involved, a large number of people are involved, and the accused seeks bail, an accused who had an active role in the said offence, seeks bail, the conditions must be strict, and there can be additional conditions too. The relevant portion of the said case may be reproduced below. That's this one. Paragraph 24 you quote.
One more citation, Lordship.
Achha.
No.
That is, you put 1. Number 2, what?
2023, volume 17, SCC 521, paragraph 17, Lordship. This is regarding claim
You have more judgments than this? These 2, or there are more?
Yes.
Okay. Another judgment relied on by Mr. C. Zoram Chama is the judgment delivered in Atul Bhai, Vitthal Bhai, Vitthal, Vitthal Bhai, Bhandari versus State of Gujarat, reported in 2023 17 SCC 521, paragraph
17, Lordship. 17. This is regarding the claim of parity in respect of conditions as those which my learned friend has cited, my lord. Now, for 17, my lord. If I may read, Lordship. Insofar as parity is concerned, we need only reproduce apt observations from Ramesh Bhav Rathod, so and so.
Whether that is applicable in the present case?
Yes, definitely, my lord. Because
in respect
now
of
they
other
are
accused. In respect of other accused, you cannot tell that
yes,
the same
yes.
accused.
Yes, my lord.
In respect of other accused, parity.
Other accused parity, yes, Lordship.
But not in case of same accused. This is in case of same accused. Parity while granting bail must focus upon the role of the accused. Merely observing that another accused who was granted bail was armed with similar weapon is not sufficient to determine whether a case. This is in case of other accused. This will not apply. Think over.
That is actually, my lord, yes, we may also omit this one in respect of item 2, my lord. 3 and 4 now, my learned friend is...
My lord, he seems what Mr. Zoram Sana is
I
saying.
would not
cannot
place that
see
in respect
parity,
of number 2, my lord.
and
now,
the conditions your lordships may set in item 2 may not be at parity with 3 and 4.
No, it is not. You read, without seeing I said that it has to be in respect of other accused, not the same.
not the same.
Here it is said, parity while granting bail must focus on the role of the
It
accused.
also,
Another accused who was granted bail was armed with a similar weapon.
my lord,
Yes,
this will be in
yes.
respect of this item number 3 and 4, my lord.
Okay, then you cut it. One judgment, it hurts so and so. And then you write, hurts so and so, okay.
Your Lordship,
It is a, yes.
have,
Oh yes, of course. Miss Venishami, yes, appearing for respondent number 1, submit.
yes, Your Lordship, I will adopt most of the objection which the council has made, and I would like to make one objection. And Your Lordship, regarding to condition number 2, here in this condition he is advised not to relocate. But we already know that he is evicted, and now the petitioner council has mentioned that they are going to look for another place. So if a specific time may be given, so that he will report it before the police during a specific time. So
Yes.
that is.
Yes.
If that,
Within specific time, he will, but then he has to find out house. Of course, I'll have to give an
yes,
extended
Your
time.
Lordship, but still, if there is no specific time, we don't know that when he will give his address. It can be after 1 year or whatever he can give, if there is no
within
specific time.
1 month.
My
So
lords,
if there is a specific time,
my lords,
that he has to give his address before the police.
my lords, the intention of the learned APP is quite, my lords, accept. But your lordships, if your lordships may, my lords, consider that I may report to the police until I find a accommodation, either once in 2 days or so, my lords. Every once in 2 days, I'll report to the police station until I find a accommodation, my lords.
Every alternate day, he has to report to
Yes.
the police station, find out
Yes,
the
if the
place,
condition is there.
and within 1 month or 2 months,
My lords, 2 months.
within a reasonable period of time.
Yes.
Yes.
Because he will have to appear before police every alternate day before till he finds out a place.
Yes. Your Lordship.
After that,
Yes.
Yes.
after he finds out a place, then that requirement of going to the police will not be required.
Yes.
That condition I'll put.
Yes, Your Lordship.
That is your submission.
Yes, sir.
Yes. So Ms. Venishami, appearing the learned APP, submits that she has objection with regard to the condition number 2 given in the bail order, that is the petitioner, although may be allowed to relocate the address, but he may do so within a short period of time, and till then he may appear before the police station every alternate day. So heard, huh? Then you write, it is a subtle proposition of law that imposing onerous condition while granting bail amounts to denial of bail, and the same undermines the fundamental right to personal liberty guaranteed under Article 21 of the Constitution of India. The conditions, as has been held by the Apex Court in a number of decisions, must be rational, reasonable, and not burdensome to the accused person so as to render the bail meaningless. It was also held that conditions that are impossible to comply with violates the accused right to liberty. If you don't understand anything, tell me, huh? The conditions which are required to be given has to ensure presence of the accused in trial and for preventing him from tampering with the evidence. And also for preventing him from absconding. But at the same time, it cannot be arbitrary, which would infringe on the fundamental rights of the accused. It be again stated that whether condition is onerous or not would again depend on the facts and circumstances, such as financial status of the accused, as well as other difficulties. It is also held by the Apex Court that giving giving onerous conditions and then putting the accused person in a position to challenge the same is a misuse of judicial process. In Girish Gandhi, right? In Girish Gandhi versus State of UP, Supra, it was observed that excessive financial deposits, and multiple sureties across the jurisdiction are considered onerous. Further, it is the law of the land that the accused person is considered innocent till he is convicted. And that the bail conditions should not negate the said presumption. Or result in prolonged detention due to non-compliance of the conditions mentioned therein. It is noticed in the present case that the petitioner was granted bail in the month of May 2025, and he is not able to comply with the conditions given in the bail order, and as such he is under detention till date. That is for 22/5, 22/6, 22/7, 2 months, more than 2 months. That is more than 2 months inside the jail, which is deprecated by the apex court in a catena of judgments. The condition that the accused has to comply with, that is, furnishing of 2 reliable sureties who are government servant posted in the area lying within Aizawl district, is, in the considered opinion of the court, is too harsh, inasmuch as it is known to all sundry, or what do you say? It is known to the sundry, or what?
Your Lordship says rightly said, my lords.
All sundry, that the accused is involved in such a big financial scam in the state of Mizoram, or more so in Aizawl, and in that circumstance, and in that facts, getting 2 sureties being regular government servants posted in Aizawl would be a difficulty, or rather an impossibility. As such, this court is of the opinion that the said condition is modified to the extent that the petitioner would furnish 2 local sureties, one being a government servant. government servant, not Aizawl and Mizoram. Working in Mizoram, working in the state of Mizoram. Because again, Aizawl will be difficult. Again, he'll be inside. Working in Mizoram, in the state of Mizoram. Where the petitioner had also challenged the second condition, in which he was directed not to leave the jurisdiction of this court and not to relocate his present address. Not present, not to relocate his address recorded in the police records without the permission of the court. Without the permission of the court. Yes, full stop. It is noticed and it has been submitted by the counsels at the bar that the petitioner has been evicted from the place where he was staying before the occurrence took place, and that the said address given in the police records are no longer his present address. It is also stated that the family of the petitioner who were also staying in the said address had also left the same and are presently staying in the state of Assam. As such, it is in the opinion of the court that the said condition should also be modified. Since there is no place of stay with respect to the petitioner in Aizawl at present, it is as such directed that the petitioner would find another place in Aizawl for his stay until he finds a suitable place for accommodation. The petitioner would report to the police officer every alternate day and once he finds the said new place, he will inform the same to the police, who will then record the address in the police records. And thereafter, if he desires to leave the jurisdiction of the court, he would take permission from the said court. With these two conditions, with the modification of these two conditions, before that you write, the other conditions mentioned in the said bail order dated 22/5/2025 remains as it is. With these modifications, this criminal petition is disposed of. Okay? It is fair enough what is the wrong in it. Okay.
Item 3.
He is laughing. Yes. Then item 2, the conditions are
My lords,
for 50 lakhs.
yes.
That is too much. I'll make it 2 lakhs. Okay, 2 lakhs. Oh, and then
My
it will
lords.
be in the same.
Yes.
Acha, wait. I have not finished that.
Your
Where you
Lordship.
write? These conditions, wait.
Okay.
Then you further write, it is also noticed that the accused is involved in 2 other cases. That is, he is involved in 2 other cases. There are altogether 3 cases.
3 cases.
He is involved in 2 other cases, being where do I get the numbers?
My lords, this is FIR number CNEO PS case number 5 of 24.
Wait,
Oh,
I am holding criminal petition 21.
Yes.
So here there,
My lords, 21 is what I've just read out. In 20, it is Azol PS case number 96 of 24.
Acha, that case number you have to insert. Okay, it is noticed that the petitioner is involved in 3 numbers of cases, and they are, give the numbers.
My lords, Azol PS case number.
Izol PS case.
Yes.
Izol PS case number
96 of 24.
9624.
Second is, my lords, CNEO PS case number 3 of 24.
CNEO. Now, police station case number 5 of 24.
Yes, my lords.
5 of 24, and the other?
CNEO police station case number 3 of 24.
CNEO police station case number 3 of 24.
My lords.
It be stated that the Honorable Apex Court in Hani Nishad versus State of UP, Supra, has observed in the facts of the said case, wherein the petitioner in that case was involved in 31 numbers of cases, and the Honorable Apex Court had modified the bail conditions and had directed the same to hold good for all 31 cases. And in this one, and in this Girish Gandhi's case,
Yes.
it was also it was also it was not segregated, it was taken together, it was given together, right?
Yes, my lords.
In Girish Gandhi versus State of UP, Supra, the Honorable Apex Court had observed
Your Lordship,
in
are
the
you
said case,
now dictating the order?
in the same previous order, not the second case. Yes, what did I say? In the said case, that petitioner was involved in cases spanning over 6 states in the country. And had further was in 6 states, and that he was faced with a situation where the accused was unable to be enlarged on bail in view of the sureties as well as other conditions ordered in multiple cases in all the states. And what was the final finding of this?
My lords, If the court master could, my lords, give that.
Give me the entire case. This is Girish Gandhi. I don't have. I can take it out. It's okay. 2004-10, right?
2024, volume 10, 674. Briefly put, my lords, what for one condition, for one state, the condition was set.
Oh, you have? Okay. What was the final direction here?
My lords, from para 31 onwards, the Supreme Court had said, my lords, for each state there would be the similar conditions which was set for one state,
Okay.
and they would hold good for the cases in those states.
And the Honorable Supreme Court directed that the petitioner may furnish, may comply with the conditions which would hold good for all affairs in the state concerned. And the same conditions is permitted to stand in all other states. So what we do here is same conditions will stay in all the three.
Yes, my lords. That is what we see.
In all the three.
Actually, my lord.
Then you do what you do is then you modify the conditions. This will go before modifications.
Now.
Huh? This will go. Just a second. I'm just arranging my paragraphs. Okay. This will go before the modifications. Or no, after. Oh, after the modifications. Good.
Yes.
After the modifications, it will lie to all the so and so. Let it remain the way I dictated. Huh? And then you take up the other case. This is finished in respect of. Okay. Then, in item number 2, here he is challenging 50 lakhs, right, Mr.
Yes,
Jordan?
my
What
lords.
is your challenge here?
Here it is, my lords, the condition set at page 36, which is 50 lakhs to be deposited by check at the Mizoram Rural Branch. Second is, my lords, the sureties of Group A officers. Two sureties, Group A officers.
This will also, what I'll do is these conditions that I have said will remain in respect of all the three, like it is done in Girish Gandhi. Here, of course, relocating is there.
My lords, here, I believe not, my lords, here. Here there is no.
Achha.
In these.
So, as far as 1 and 2, there will be changes in
Yes.
this particular matter. What I'll do is I'll give bond of 2 lakhs, same, huh?
Yes.
And 2 local sureties, one being government servant in Mizoram as it was, okay, and the rest shall attend regularly court without fail. Okay, this will be there. If the accused is absent for remaining conditions 3, 4, 5, 6, 7 will
Yes.
remain same. There is no difficulty, Mr.
No, my
Varman
lords.
Sharma.
My lords,
There is no difficulty.
Actually, my lord, regarding this also, my lord, I'd like to.
Here he has said he will not leave Mizoram without prior permission. Fine, he will not leave me.
Yes.
He will be here. He will not temper. He will not threaten. And he shall attend
Actually, this he will not temper, he will not influence witnesses, all these conditions, my lord. That to give assurance, my lord. How can he give assurance? Now he is a very influential man. He is a prime accused in the present offence, my lord. So
that we all know.
that is exactly why, my lord, it is very dangerous to be reasonable. Actually, now to impose these conditions for him, who is prime accused in the present offence, my lord.
No, rest of the conditions will remain. Only 2 lakhs and then 2
2 lakhs
local
is little
sureties.
too low, my lord. Actually, from 50 to 12.
No, see, you know.
He has a means, my lord. Now, he said
No,
that 50, 50.
what he has said is that the state has freezed his account. So
my
you
lord.
know that, right? It is a fact. What is according to you? Is it a fact?
Yes, some the accused that we have known so far have now been freed. That I can admit, my lord. But he now is also having his family, and the family also has to rely on some other sources, my lord. Apart from the accounts freeze now, there are also some accounts which are not freeze, my lord.
No, that the state has seen, and it has correctly done so.
Yes.
So
They could have
50
freezed
is
the
not
other
too much,
accounts
my
also,
lord.
they have not.
Taking into account the gravity of the offense, my lord. Actually,
Offence is same with regard to all the three.
as I have, my lord, placed before your lordship that now he is a prime accused and he is the main culprit, and taking all these into account
No,
together with the
these three FIRs are in respect of the same offence.
same offense. Yes, my lord.
Same offence. So again, same conditions will lie as in Girish Gandhi. Okay. So what you do here is, rest will remain the same.
But regarding this, my lord, this is not
Your
charge sheeted.
objection will also be there in this.
This is not charge sheeted, my lord. 21, if I'm not mistaken,
Okay, then fine.
is
He
not
will-
charge sheeted, my lord.
he will-
So one accused now already absconded,
We are not concerned. We are concerned with
my
Jackie
lord.
himself.
One accused in this CNEO 5 has absconded, so investigation cannot now be completed, my lord.
My lords,
So
No,
this is
these,
charge sheet has not been
see,
filed in
he
respect
will
of the
go,
present case.
the condition that he will go every alternate day will also remain here. So same conditions will be here. He will go, and the guarantors will be liable.
But on that alternate day when he is not attending the police station, my lord, he will all go and very
The
far.
police has
to-
long hands. Don't worry, he will attend. And then there are other conditions.
my lords, I must state one thing. If my lords, the fear is that he may abscond, your lordships, I had filed a PIL regarding the poor conditions of the road. So my lords, even the trucks are not being able to ply. 500 trucks are, my lords, stopped in one way of the highway. So my lords, there is a huge chance he will not be able to. As your lordship says, long the hands of the state.
In fact, in one of the decision in, I think, Nagaland bench, there also one person was involved
This
in
is
a
my
big
lord,
scam.
My lords.
And then it is said that that was also a big issue there in Nagaland. And then also there also bail there was sufficient, and I had modified, because you have to grant him bail. When bail is granted, it's not that. So he will appear. Same conditions will appear in both the cases. And what you write is
At least, my lord, 10. Let's make it at least 10.
which one?
These 3 and 4, my lord.
What do you want?
3 and 4 to be deposit, 10 deposit at least, my lord.
10 lakhs.
10 lakhs, my lord.
That will be too much. See, even
No,
Supreme
my
Court
lord,
has
how,
said,
how lordship can say too much? They themselves are now, my lord.
no, then again, it is like giving different conditions in different. So that will go against. So one person, one
That
case,
is exactly why, my lord, now we are challenging
Your
the
lordships, we
one
consider this, my
wherein
lords.
2 lakhs is stated to be deposit.
See,
That we have
it's the
challenged.
same
So-
case, it's not a different case, same case. I mean,
That-
bail,
that is exactly
bail
why.
bond separate in different case, separate in
We are
different
aggrieved
case.
with that also, my lord. Different. That is why this lenient view taken in that first case, we have now challenged it, my lord. So
Don't worry, it's only bail. Okay, so 2 lakhs in others, to item number 3 you write, the bail conditions are modified, from there the changes will come. The bail conditions are modified to the extent, oh no, even the submissions will differ. Okay, right. Mr. So-and-so and so-and-so, that will say, then you say Mr. Robert Jordan has challenged the bail conditions to the effect that the petitioner was directed to furnish a bail bond of rupees 50 lakhs to be deposited by check at Mizoram Rural Branch, Treasury Branch account of this court. And the other condition, that the petitioner was directed to furnish 2 sureties who should be gazetted Group A officers who have to be gazetted Group A officers working under the Government of Mizoram and posted at Aizawl and duly certified by the controlling authority. Then you give those decisions and all, then my findings. It is noticed, it is stated at the bar by the counsels for both the parties that it is an admitted fact that most of the accounts of the petitioners were freezed by the government, by the
Investigating authority.
in view of the instant case. And as such, it is in the opinion of the court that asking the petitioner to furnish a bail bond of rupees 50 lakhs is unfair in the facts of the case, and the same is too exorbitant. Since the petitioner is involved in the same case for which he was granted bail with the condition that he should furnish a bail bond of rupees 2 lakhs, the same may be also provided here. As such, this court directs the that the condition number 1 provided in the bail order dated 15/10/2024 in connection with CNEO PS case number 5 of 2024 may be modified, and the
Two
accused.
lakhs, my lord. 2 lakhs is too less, my lord. Now we are talking about an offence wherein the present petitioner is the prime accused, my lord. And the amount involved is 150 crores, not even lakhs, my lord. 150 crores.
Lordships,
No, these
so
are
this is
bail
not the
bonds.
proceeding.
This is
That is
you-
exactly why, my
This is
lord.
not where
Exactly why.
Let the
exactly
case
why
be, let him
I-
be convicted first. These are allegations. Let him be
No.
convicted first.
I know that, my lord. But
Because you
now,
see-
even before that, my lord, the stricter conditions is allowed to be imposed in
Now see,
accused in
now-
economic offence
now if-
standing
now
a
if
different
I gi-
footing, my lord, different footing, my lord.
Now
That
if
you
I
will have
give
to,
again-
your lordship may understand, my lord, in different footing, my lord.
No, see, the court has said that you give conditions, then again you make the person come for modification is a wastage of court's time. So I give 10 lakhs today, then he'll again come for modification. He will not be able to go out, then there will be violation. It's okay. I'm giving you 2 lakhs, you challenge it before Supreme Court. I give you 2 lakhs, furnish a bail bond of rupees 2 lakhs. Then full stop. Then come to the second thing. As far as the second condition is concerned, this court finds it fit that the petitioner may furnish 2 local sureties, one being a government servant working in the state of Mizoram, as has been provided in the other case. Rest of the conditions mentioned in the said bail order from condition number 3 to 7 would remain the same. With this modification, this petition is disposed of. Rest will remain the same. Your objection will be there. Then again, third, we have a meeting today. 114 or 115 or 1, just asking. Some in the judicial quarters. Then third the same conditions.
My lords, page 31. a bond of 50 lakhs guaranteed by a suitable surety. Then at page
50
31.
lakhs.
Yes, please.
This is will also remain the same. Bail is subject to following conditions then.
My lords, 32, I have to report.
Every day at 9 a.m.
Yes, 9 a.m. And now, second, my lords, second point. And lastly, my lords, the ending paragraph. The surety shall be a permanent resident of Aizawl, duly certified to the effect by chairman of local area council concerned. Surety shall, in addition to a certificate of the chairman of local area council deficit, put up as security for bail his own land settlement certificate.
This is very reasonable.
150. Okay, this one will, No, this will, I'll pass it in the chamber. Right. Okay, first is 50 lakhs.
Yes,
Okay, Bunty, we will come back at again at 2. I have a meeting.
my lords.
Okay? If you have something more to say, come with that. Chalo. We'll come back at 2.
Obliged.